WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. It is Wednesday, May 14th, 2014. It is National Dance Like a Chicken Day, by the way. John Fuller is here to answer your questions about the law. The show is called Legally Yours. John Fuller is an attorney at the law firm of Fuller & Fuller. The other Fuller is his beautiful wife, Janet. And John coming in and at the tail end of the same thing I think I've been going through, some kind of cold or something. Good morning, John.
Good morning, and good morning to all our listeners. We hope everyone is healthy and enjoying some summer weather. I know before we went on the air, you and I were comparing the fact that there's been a spring cold running around that lays everybody low for a week or two, so we hope all our friends and listeners are doing well.
So you, like I, use your voice for a living, because obviously in court you have to be able to speak and speak well. And obviously, the thoughts behind the words are important. Did you have any court cases while you've been under the weather?
It's hard to talk when you're coughing about every 2 seconds. That's for sure. So, it's been a challenge. We were talking before the air and going on air. It's theoretically. You go home, you rest, you take fluids, you drink chicken soup, you do all those things. Who has time in the society that we live in today with the responsibilities that we all have in our respective jobs, careers, professions, to just say, time out, I'm going home for 3-4 days and take vitamin C and drink chicken soup.
Use your vacation time on the nose.
Well, it's there was none. So anyway, but I'm glad you're feeling better, Larry, and hopefully our listeners are all hale and hearty.
Yeah. So I don't know if you're listening right now and you have a question, we would love to hear from you. Sometimes we bring in some national stories into the show just to kind of jumpstart it a little bit. And right now they're all so drawn out. The Pistorius story, and Pistorius being in South Africa, it almost is non-applicable to the questions we might have here.
That's true, and I really haven't followed that. It's amazing how long those trials take. The jury trial system is a little troubling because the number of jury trials have gone down, which means a lot of people aren't exercising their right to have their day in court because it is so expensive and time-consuming, because trials have gotten extremely complicated and complex and very time-consuming. Now, Florida is nowhere near as bad as California. California trials, average trial length in California is several days longer the same type of case than the same case in Florida. But the case that's going on with the Olympic athlete, the amputee, that seems to have been going on forever. But that's not a jury trial, as we talked about a couple of weeks ago with a caller.
Yeah.
They're just a judge doing that. So hard to understand. Some trials are very complex and they do take a long period of time, but that is unusual. And I think it's important that we keep our courthouses and courtrooms open so that people can have reasonable access to jury trials, because it is by far the best dispute resolving tool that I think's ever been invented. But it's a kind of a diminishing art form of having jury trials, and I think society loses when that happens. But I don't know the answer to it. Could be like most things, we need more judges, which means you need more money. But anyway, we do the best we can. I got a caller, I see.
Yes, sir. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller.
Good morning,
Larry.
sir.
How are you guys
good.
today?
How are you?
Oh, so far so good. I had a question in regards to this lady that I guess shot her kids that's on trial in Tampa. I understand a person can be mentally ill, but not necessarily held mentally incompetent. when they're standing trial. I understand. I was listening to one of the pundits the other day, and they were saying that if a person knows the difference between right and wrong, it doesn't matter whether they have a history of mental illness or whatever. They still can be held mentally responsible. I'm going to hang up and listen to your answer on the air. Thank you very much, and you guys have a good week.
You too, sir. Well, not the issue of a citizen who's charged with a criminal offense who pleads not guilty by reason of insanity. And that's, they teach whole courses at law school about that, so we obviously won't deal with it. But your understanding in a very general way is accurate. The question is not whether or not the person has some mental illness or whether or not they are have some personality disorder. The question is, at the time the act was committed, the person had the mental capacity, the cognitive ability to know and appreciate what he or she were doing and the consequences of their action, and that it was a criminal offense. Then that's question number one. There's a two-stage question. Then the next question is, at the time the individual has been charged and would come to trial, is that person mentally competent to provide assistance to his lawyer so that he can have a fair trial and due process of law? Because if a person is so psychotic, so completely out of it with paranoia, schizophrenia, what have you, that they can't communicate with their lawyer to effectively assist their lawyer to prepare their defenses, how can they have a fair trial? So then you have a determination. So there are two stages. Number one is was the person lucid and competent to stand trial at the time based upon their mental status at the time the alleged act was committed. Number two, at the time they would be tried, are they mentally competent to stand trial? If they are not, then the trial has to be stopped. They have to be placed in a mental treatment facility as an inpatient. They can't go and come. They're secured, and they have to take psychotropic medication. And if they can control their symptoms, and there was a great social debate about this. I was on the Criminal Rules Committee back in the 80s and of the Florida Bar. And one of the questions is, if a person isn't normally capable of assisting counsel without artificial intervention of psychotropic medication, does the government have the power to order a person to take psychotropic medication so that he will be mentally lucid enough to be tried for murder?
Oh, wow.
And they basically resolved the question that yes, that if you put someone in a treatment facility and you treat them, and they ultimately become competent to stand trial, then they go to trial, and then the question is, were they mentally lucid to know the difference from right and wrong at the time the alleged offense committed? If the jury determines they were not, like they did with the guy that shot President Reagan, then he is found not guilty by reason of insanity, and he is placed in a mental institution where he remains until he would be determined that he was no longer mentally insane.
And in his case, he's still there, right?
In his case, he's still there, and in most cases, they're still there.
Wow.
Okay, hope that helps. It's a very complicated area of the law, and that's about the best I can do in a few minutes.
Do you know, I wondered about evidence that is dug up by an investigative reporter. My father was a policeman in New York City, and before Geraldo Rivera was famous, Geraldo Rivera was actually doing investigative reporting in New York City. And so I don't know any specific details, but I'm just curious in general, if you're conducting a trial, or you're part of a trial, and all of a sudden there's new evidence introduced because an investigative reporter dug it up somewhere, is that looked upon favorably? Does the judge?
Well, first of all, it doesn't really. If new evidence is discovered, the source of the evidence is only going to be analyzed to see if it's reliable. You have many trials where some inmate in jail comes in and says, "Oh, I'll turn state's evidence and I'll testify for the prosecutor that Joe Blow, who was my cellmate for 3 months, confessed to me that he did kill so and so."
Yeah, right.
And by the way, now that I'm a cooperating state witness, I would sure like to have my sentence reduced. And a lot of times they cut deals with people like that. Well, you can see on its face that there's some issues of reliability, credibility,
Right.
that sort of thing with
Right.
that. But it really, the question is the newly discovered evidence, when is it discovered? I mean, and could it have been discovered before the trial by due diligence? If it's discovered after the trial because the defendant and his defense team didn't properly investigate, didn't look, it may not be sufficient to get a new trial.
There was a story this morning about a guy who lives in Louisiana who says he's written a book now saying his biological father was the Zodiac killer of Northern California back in 1968 and 69. I don't know if you know that.
No.
I didn't know it either. But apparently he's written a book saying my dad was. And now all of the people in charge in the San Francisco area are looking at the book saying, I don't know. I mean, this guy could be just fabricating the whole thing just to sell books. It could be the same thing as the cellmate who decides to, come up with some wild story that nobody knows whether to believe it or not.
Sure. Well, I'll tell you what's been the biggest and the most impressive evidentiary tool to help right wrongs that the criminal justice system has allowed to happen. Even though it's the best system that I think's ever been invented, it's far from perfect. And the DNA evidence and the DNA science that now exists has exonerated more people who were convicted and sentenced to death row and served years on death row.
Wow.
And then they are able to go back, open cold cases, find old bodily fluids, do DNA testing, and conclude that the individual could not possibly have been the perpetrator of the crime. And I used to know the statistics, I don't remember now. It started with the Innocence Project in New York with Barry Scheck and his partner, and there are hundreds of people who have been released from jail because of DNA. And we didn't have that science 25 years ago. I think it started probably emerging about 25 years ago. But that has been the single biggest newly discovered evidence that has exonerated countless number of citizens who were wrongfully convicted, many of them on eyewitness testimony, which parenthetically, we've talked about it before, is probably the least reliable testimony there is.
That is fascinating. If you have a question for John about your legal circumstances, maybe it's not as heavy as a murder. Maybe somebody's suing you, or you're thinking about suing somebody. This is a good time to call John. We are live on Wednesday, May 14th, May 14th, 2014, and the number to call is 622-9622, 622-WOCA, the WOCA Climate Control Source Hotline. Yeah, there are a couple of things in the news, I guess, that we look at, specifically for Florida with the whole the warning shot thing. That's still something they're talking about. And
yeah, that's I think that's a remedy without a problem that invites more danger and risk than anything it's designed to cure. I think it grew as a kind of a knee-jerk reaction out of some high-profile criminal cases that happened in the last year or so, and they supposedly engrafted it on as some kind of a compromise on the so-called stand your ground law. I don't understand it. All I know is that all the instruction, all the professionals, all the people I talk with say that randomly firing a so-called warning shot is not recommended. Every time a projectile is discharged, it's got to land somewhere, and the risk of some innocent bystander being hurt by that is, I think, far outweighs any justification of firing a warning shot under the theory that will avoid using lethal force. If lethal force is legally warranted, then the law allows you to defend yourself using lethal force.
So the lady who was put in jail for 20 years up in Jacksonville, the one who brought this story to our attention, really, well, her case did.
Right.
Would she have been better off if she shot? I think it was her ex-husband.
I don't know the facts about that, but the bottom line is that bad cases make bad law, and sometimes the facts are just really bad, where you're making choices between two co-equal evils, and that's always a bad situation. And our criminal justice system's not perfect, and bad cases make bad law. I don't know enough about that case. I know the lady was being attacked. I know she thought she was shooting a warning shot,
right?
And she, got sentenced because of it, and they ultimately mitigated her sentence and then passed this law. The question is, was she entitled to use lethal force? I don't know enough about the facts, but those are difficult questions. It just, they're not easy answers when you're dealing with those kind of complexities.
Well, but along the same lines of the unjust sentence of a person who didn't do it at all and was later found to be innocent because of DNA.
Yeah.
In her case, she was she shot into the ceiling apparently, and yes, you're right. That stray bullet could have gone to somebody innocent. But
yeah, like the people that lived in the apartment upstairs.
If there was, well, I don't know if there were. Anyway.
I don't know either, but or you shoot it down in the ground, it hits the concrete, it ricochets and goes 500 yards and shoots a baby in a stroller.
But couldn't you, as if you were her defense attorney or any defense attorney with somebody who's in trouble because they've shot a warning shot, couldn't you convince a jury somehow that to say, look, my client didn't hurt anybody and was in fact trying to not even hurt the perpetrator of the real perpetrator here? I mean, couldn't you use that as a defense?
Yeah, of course. And if nobody was hurt, then you have a lesser included type charge. Reckless discharge of a firearm, reckless display of a firearm. They're lesser crimes that one could be prosecuted for. And I think this was designed to somehow legalize the right to display and discharge in a preemptory fashion. I just think the risk for danger to innocent third parties is significant enough that I would seriously question the need for that law, because we have plenty of laws on the books that don't even get to stand your ground. You have a right to use lethal force to defend yourself. If you or someone that you're with, a loved one, a family member, or any other person is exposed to imminent bodily harm, imminent serious bodily harm or death, you have a right to use lethal force to defend yourself.
The other day there was a local story in Dunellen. There was 3 people, 2 women and a man, and one of the women had a car, and they convinced the woman to drive them somewhere. Anyway, they went to park someplace and smoke marijuana. They then tied her up, put her in the trunk, and she called police on 911, and they caught them in Ocala. They got her out of the trunk, and so all's well that ends well. Well, for her. I think, wow, these 2 that just got arrested are better off now being caught than if they had murdered the woman, which is probably what they were going to do. I don't know. But the other part of this question is, the woman who was being kidnapped came right out and told the deputies, yeah, we went to go smoke some marijuana. So does she get off the hook simply because, wow, you were being kidnapped, and so we'll forget that whole marijuana thing? Or is she still subject to...
She's still subject to being prosecuted.
She could?
Sure. But it's a lot better even if you're stoned on marijuana, but if you can call 911 and avoid being killed, a misdemeanor marijuana charge sounds a little bit like a traffic infraction.
Yeah. Is marijuana a misdemeanor?
Depends on the amount.
Oh, okay. So just saying you smoked marijuana could incriminate yourself.
Well, I think they probably found some evidence of marijuana in the vehicle. From what I remember saying, they found residue, or they found, some marijuana in there. And I don't know that, given what she went through, that the prosecutor might not exercise his prosecutorial discretion and good common sense and say, this lady's been through enough, and we don't need to add to that. She probably won't repeat that behavior in the future. I don't know. But prosecutors have that authority, and good prosecutors who take their oath of office serious, which I've found the vast majority of them do. I think they will, look at that case for the totality of the facts.
Does a judge look at the two who were arrested and say this would have gone farther had that woman not called 911?
I don't think you can project and punish for an offense that didn't occur.
Well, not punish, but recommend therapy or something
I have no idea.
Or rehab or something.
It's hard to answer a question like that. First of all, they're charged with a number of serious felonies. So the question is, are they going to be found guilty or innocent of that? And then what would be the appropriate sentence?
The number, if you want to call John, is 622-9622. We've got a few minutes left if you have a question, especially regarding your own legal circumstances. And pretty much you handle these types of cases, right? You're not.
We have over the years done a very active criminal defense practice. Right now, I do not do a volume criminal defense practice. I am open to consult, and I do take select cases, but they are usually extremely large, high-profile cases that involve major issues.
And you have a phone call. Good morning. You're on the air with John Fuller.
Good morning, Larry, and good morning, John.
Good morning. Fine, thanks.
John, I'm sorry about the loss of your friend, the World War II actually hero he was.
He was a special. His name was Ben Daniel Jr., and he was
a veteran. I want you to know that I and a respecter of the law that and of yourself, that I appreciate both of your service to the metro area of Ocala and to your country.
Thank you.
A lawyer that does what John does is a contributor to the rights provided to us as Americans, and that's what brings me to call you, John. Is if you could just please touch on the fact that how important a lawyer is when they're coming up against an insurance company or a large auto manufacturer. In other words, the victim versus the corporation in many situations. If you could.
Thank you so much.
Not trying to. All right. Thank you.
Yeah, thank you for your kind comments. But you make an excellent point. We've talked on it before, and I think this probably affects what the average person deals with. When you're in an automobile accident, or if you trip and fall on an improper, negligently maintained premises, you definitely need a lawyer, because most drivers, most premises owners have liability insurance, and those are big companies who hire professional adjusters whose sole job is to try to settle all cases as cheaply as possible, or for nothing if possible, so that the corporate entity, the big insurance company, keeps more money in its coffers to pay to its shareholders. That's the bottom line. And it's an adversary proceeding, and the insurance company representing the driver or whomever, they have professional negotiators on their part who are going to try to attack and to pick apart every bit of evidence. They're going to try to say their accident didn't cause it, you had it before, or if you didn't have it before, their accident didn't cause it, but you've had a subsequent intervening accident. They're going to say it's chronic. They're going to say it's non-acute. They're going to say you don't need surgery. or you haven't had surgery, therefore you shouldn't recover for the future surgical bills. You need a professional to represent you in that, and you need it early on in the case, because lawyers, the tools they work with are the evidence that they're able to compile, and the expert witnesses that they have.
Right.
So if you're in an automobile accident and you don't have a lawyer and you want to talk to somebody, call our office. It's vitally important that you seek medical attention with a medical doctor, an osteopathic physician, a physician's assistant, or an advanced registered nurse practitioner within 14 days of the accident, or you could lose valuable rights. So we've talked about this before, but absolutely the gentleman that called makes a wonderful comment, because the people that call you on the phone, who are utterly charming, want to get you to make a statement. Don't make a statement to them until you get you talk to a lawyer. It may be appropriate to make a statement, but talk to a lawyer first and
Absolutely,
have that right,
yeah.
because they're going to try to ask questions to try to at least raise questions that are going to be helpful to defending the case, diminishing their client's apparent negligence, enhancing an argument that you are comparatively negligent, and minimizing your injuries, or arguing that the accident didn't cause the injuries in the first place.
John, we are out of time. What's your phone number?
Our office number is 352-547-4292. Our toll-free number is 855-534-2565. We have offices in Ocala and the Villages.
Thank you, John.
Thank you, Larry.
All right, we'll take a little break and be right back.
Broadcasting from the Paddock Mall Studios, this is WOCA, Ocala, Gainesville, The Villages, 1370 AM, 96.3 FM, The Source.
Yeehaw! Howdy, folks. RL here to invite you to DQ. Dairy Queen is serving the crispiest, juiciest, most tasty chicken tenders, all beef chili dogs, and quarter-pound cheeseburgers on earth. And you get crispy fries, a drink, and an ice cream sundae of your choice for only $5. Remember,